Congratulations and welcome to Unit 8. In this unit, we're going to talk about the formation defenses. And specifically in this subunit, we're going to talk about the formation defense of duress, also known as coercion. All right, let's introduce the idea of formation defenses. Formation defenses are effectively what we might call affirmative defenses. In other words, when you plead a formation defense, you're saying, assuming there is a contract because we have assent, reasonably certain material terms, and consideration. Even assuming that we have a contract, this contract should be unenforceable because of one of these formation defenses. Now, the language you use is that the contract is void for some of the defenses, and for some of the defenses we use the language unenforceable. All right, what are the formation defenses? Well, here they are. The formation defenses are duress, misrepresentation, incapacity, undue influence, illegality, a violation of public policy, or unconscionability. We'll go through each of these defenses one by one. First, let's talk about the defense of duress, the formation defense of duress. Remember, what we're talking about here is that we're admitting, at least for the sake of our pleadings, that there is a contract. We have assent, reasonably certain material terms, and there is consideration or promissory estoppel. So the argument then is that even though we have a contract, this contract should be unenforceable because I assented to it under duress. Now, duress is also sometimes called coercion. So here are the elements of duress. A contract is voidable by the aggrieved party if the other party made a threat that was improper, it induced the aggrieved party to assent to the contract, and the threat was sufficiently grave to induce assent. Okay, so here are the elements of duress. We'll go through each of these elements one by one, but we are going to focus on whether the threat was improper and whether the threat was sufficiently grave to induce assent. All right, so let's introduce the idea of whether a threat is improper or not. So here's just a little example to set it up. So Mary and Bob are negotiating the sale of Blackacre, a plot of land. And Mary says, Bob, if you do not agree to sell Blackacre to me for $200,000, I won't buy it from you. Now, is that a threat? Yes, Mary has clearly made a threat against Bob, right? If you do not give me the land for $200,000, I won't buy it. But is this threat improper? No, it is not improper. If this type of threat were improper, then every contract, virtually every contract would be made under duress. Every time you enter into a contract, you're negotiating the price. And you say, if you don't give it to me for this price, I won't buy it. Or if you're the seller, you're saying, if you're not going to pay this price, I won't sell it. That leaves us a question then, what type of threats are improper? We're going to discuss that in the next few slides. All right, so we're discussing what types of threats are improper. And our first category of improper threats are threats that would be a tort or a crime. So for example, assault, a threat to assault someone, a threat to commit battery, a threat to trespass on someone's property, or some sort of a threat of extortion or blackmail. These things are torts and crimes, and therefore they are improper threats. So in the fact patterns, when you're taking an exam or in real life, when a client comes to you with a case, you are looking for something like some sort of threat to harm one's person, or threaten to harm someone's property, or threat to reveal someone's deep, dark secrets. Those are all improper threats. And remember what we're setting up. I threaten this, and that induces you to enter into a contract with me. All right, so it's pretty clear that when something is unlawful activity, and unlawful will describe broadly or will define broadly as either tortious or criminal, that is an improper threat. So if you threaten a tort or you threaten a crime against someone and they enter into a contract with you because of that threat, then that contract is voidable. You made an improper threat. But what if you threaten some sort of lawful activity? All right, well, let's look at some of the things that you might threaten to induce someone to enter into a contract with you. You might threaten to sue them. If you don't enter into this contract with me, I will sue you. Or you might threaten to bring criminal charges against someone. If you don't enter into this contract with me, I will bring criminal charges against you. Or you might already be under a contract and you might say, listen, if you don't modify this contract, I will not perform my obligations under this contract. Is that an improper threat? Finally, there are numerous legal activities, lawful activities that you might engage in, and you might threaten to do any one of those activities to induce someone to enter into a contract with you. Is the threat to engage in some sort of lawful activity improper? Let's talk about it. All right, first, let's talk about the threat to bring a civil suit. So here's just a little example so that we have something to talk about. Bob hates Mary's shed. It's on his land. He sees it. He hates it. It's an eyesore. In a fit of rage, he burns it down to the ground. Mary says to Bob, Bob, if you don't pay me $3,000 compensation for burning down my shed, I will sue you. Mary threatens to bring a lawsuit. Bob agrees. Bob agrees, he says, okay, I will pay you $3,000. Now we have a contract between Mary and Bob. Bob promising to pay Mary $3,000 for burning down her shed. Did Mary make an improper threat? And the answer is no. If Mary believed in good faith, if Mary had a good faith belief that her claim against Bob was valid, then her threat was not improper, right? And we talked about good faith. We've talked about this a lot. There's usually a subjective element in good faith. Did Mary honestly believe she had a good claim against Bob? And then there is the objective standard. Did Mary reasonably believe she had a valid claim against Bob? We saw this when we talked about consideration and when you give up an invalid claim under the consideration analysis. Is it a legal detriment? Well, here we're seeing basically the same standard again. If you had a good faith belief in your claim when you threaten to sue someone, then it is not an improper threat. Now, of course, the converse would be true. If you don't have a good faith belief in the validity of your claim, then when you threaten to bring a civil lawsuit against someone, it is an improper threat. All right, let's move on to the next situation. What if you threaten to bring criminal charges? So we have the same fact pattern where Bob burns down Mary's shed and Mary wants Bob to compensate her $3,000. This time she says, Bob, if you do not promise to compensate me $3,000 for burning down my shed, I'm going to press criminal charges against you. Here we have a threat from Mary. Is Mary's threat to bring criminal charges improper? First, before we answer that, let's look at it from the perspective of whether this is a lawful activity. Is it a lawful activity to bring criminal charges against someone? Yes, but this is the law. This is an improper threat. What's the justification for calling this an improper threat? Well, what courts have said is that this is an abuse of the legal system. We're not going to let you use the criminal legal system to induce someone or threaten them to enter into a contract. So you threaten a civil suit, it's not improper as long as you have a good faith belief in the validity of your claim. You threaten to bring criminal charges, this is improper, period. All right, moving on now. What if I threaten not to perform my legal obligations under a contract? Well, this is lawful. It's not unlawful to breach a contract, and it's not tortious to breach a contract, right? It's not a crime, and it's not a tort. All right. Usually we're seeing this in a threat to breach or a threat to not perform one's obligations under a contract in order to get the other party to modify a contract. So here's our example. Party A and Party B enter into a contract where Party A grants Party B the exclusive right to use Party A's trademark. Right? Party B promises to pay an annual royalty of a fixed amount. Right? In year 2, Party B says, if you do not agree to reduce the royalty I have to pay to you for using your trademark, then I will just stop paying the royalty altogether. Here we have a threat from Party B. I will stop paying the royalty under the contract, what I'm contractually obligated to pay. I will stop those payments unless you modify the contract. Right? And then in the A, Party A agrees. So the threat induced Party A to enter into the contract. Is Party B's threat to not perform her obligations under the contract improper? All right, so let's talk about this in a little bit more detail. So when you modify a contract under this situation where you threaten not to perform your obligations under the contract in order to induce the other party to modify the contract, the other party has two arguments. The aggrieved party has two arguments. The first argument is consideration. Remember we talked about modification of contracts under the common law requires consideration. So go back to those lessons and make sure that you can make that argument. In this case, we also have the threat, and so there's a duress analysis that we also want to make. So the aggrieved party has two arguments in, we'll say, in defense of the modification of the contract. Let's talk about duress. So was Party B's threat to not perform her obligations under the contract improper? And this is the law. A threat to not perform your obligations under a contract is improper unless you had some sort of good faith belief that you had a right not to perform. Once again, you have to have a good faith belief in your right not to perform. If you don't have a good faith belief that for some reason you have a right not to perform, then your threat not to perform is improper. So what would give you a good faith belief? What would be the basis of your good faith belief that you have a right not to perform your contractual obligations? Well, number one, there might be some language in the contract that you read, right? You honestly read, and that you reasonably read to give you a right not to perform in whatever situation has arisen in the particular case. What else might give you a right not to perform in your contract? Well, the law. Maybe you have some sort of legal argument. Maybe you can argue that there was no assent, or the terms of the contract are not reasonably certain, or there was no consideration. Or maybe you can argue any one of the defenses that we're learning in this unit. Or maybe you'll learn some of the defenses, or you can argue one of the defenses that we'll learn a little bit later in the course. In other words, if you do not have a valid, good faith belief that you have a right under the contract to refuse to perform, then your threat not to perform is improper. What could be the basis for your belief, your good faith belief that you don't need to perform your obligations under the contract? Well, there might be some language in the contract, or the law might give you a right not to perform because of some sort of defense or some sort of excuse, or because we're missing assent, reasonably certain material terms, or consideration. What if you threaten some other lawful activity? You threaten to engage in some sort of lawful activity to induce someone to enter into a contract with you. Well, here's the rule. The rule is if what you threaten is unrelated to the requested benefit and you enter into a grossly unfair exchange, your threat is improper. All right, let's just look at one example to kind of flesh out the issues. So Bob lives next door to Mary, and Mary has a classic car, and Bob wants Mary to sell him that car. Bob makes a threat. Bob says to Mary, Mary, if you do not agree to sell me your car for $1,000, I will keep chickens in my yard. Now, local ordinances in this particular place allow Bob to keep chickens in his yard. So he has threatened to engage in lawful activity. Mary is afraid that if Bob keeps chickens in her yard, it's going to lower her property value. They're going to make a lot of noise. They're going to stink. They're going to attract rats, whatever. So Mary agrees to sell her car to Bob so that Bob will not keep chickens in his yard. Bob has made a threat. It has induced Mary to enter into a contract. Is Bob's threat improper? If Bob's threat is improper and we meet the other elements of duress, Mary can void this contract. So Bob has threatened to engage in a legal activity, but his legal activity is unrelated to the requested benefit. There is no logical connection between keeping chickens in your yard and the sale of a classic car. Second, did the parties enter into a grossly unfair exchange? Well, the facts say that they entered into a contract for the sale of a car for $1,000. And the facts also say that the car was worth at least $20,000. So based on these facts, it looks like the parties entered into a grossly unfair exchange. What does this mean? Well, this means that Bob's threat was improper. And if the other elements of duress are present, Mary can void the contract. All right, so we've looked at several elements of duress so far. We've really only looked at one. We've looked at the element of improper, and we said we're going to spend some time on sufficiently grave. So now let's move into the element of whether the threat was sufficiently grave to induce assent. All right, so we're going to talk about whether a threat is sufficiently grave to induce assent, and I can only think of some silly examples that come from movies. So imagine if someone says, if you do not promise to pay me $1,000, I will tell the police that you picked your feet in Poughkeepsie, right? Have you ever seen the movie The French Connection? This comes from that movie. In any case, here we have a threat from one party threatening to tell the police that you picked your feet in Poughkeepsie, right? Is it improper? You're telling the police, yeah, it's an improper threat. But should you succumb to this threat, or should you just say, go ahead, tell the police, what do I care? All right, so here's another one that comes from a Monty Python movie, Monty Python and the Holy Grail. I don't know, I just thought it was funny. So if you do not promise to bring me a shrubbery, I will repeatedly say, "Nee." Does this make sense? No, it doesn't make sense, but if you see the movie, it's funny. So is this a threat? Yes. Is it improper? Yes. It looks like it's completely unrelated to the requested benefit, so it's an improper threat. The question is, should you succumb to this threat? And the answer is no. That's the idea of whether the threat was sufficiently grave to induce assent. All right, the examples I just gave were pretty silly and were pretty obviously not threats that are sufficiently grave to induce anyone to enter into a contract. But what approaches will a court take? What test will a court use to determine whether a threat is sufficiently grave to induce assent? There are effectively three approaches. A court will take any one of these approaches. So the first approach is the subjective approach. The second approach is the objective approach. And the third approach is also an objective approach, but it's given a different name. It's the no reasonable alternative approach. Let's talk about the subjective approach. In the subjective approach, we just ask whether the aggrieved party honestly gave in to the threat. Right? We don't ask whether a reasonable person would have given in to the threat. We ask whether this party in this circumstance her will was honestly overcome by the threat. The objective approach, you probably could have guessed by now, is we ask, would a reasonable person of ordinary firmness, would that person have succumbed to the threat? And the last one is, did the victim, did the aggrieved party have some sort of reasonable alternative other than assenting to the contract in response to the threat? Once again, a court will use one of these three approaches. All right, back to our elements of the cause of action for duress, or the defense of duress. So we already talked about whether a threat was improper. We already talked about whether the threat was sufficiently grave to induce assent. And that leaves us with two pretty straightforward elements. Was it a threat? And did it actually induce the aggrieved party to assent to a contract? Once again, these are pretty straightforward, so we'll go through them rather quickly. All right, let's talk about whether there was a threat. So threats can be expressed, and most of the examples I've given up to now have been expressed threats, where one party threatens another party. Now, naturally, you don't have to use the word threat, right? So anything where you're threatening is an expressed threat. But there might also be implicit threats, right? And what you have to ask is, what did the aggrieved party reasonably infer from the other party's language or conduct? Did the aggrieved party reasonably infer a threat? That's the question you need to ask. You just have to look at the facts and do an analysis based on what a reasonable person would have inferred from the other party's conduct or words. All right, let's talk about the final element, whether the threat induced the aggrieved party to assent to the contract. Once again, this is a pretty straightforward element. Sometimes the facts will be clear, and sometimes you'll have to infer that the threat induced the aggrieved party to assent to the contract based on the timing. So first, sometimes the facts will say something like Bob felt he had no choice but to enter into the contract with Mary because of Mary's threat. And therefore, the facts pretty much clearly state that Bob was induced by Mary's threat to enter into the contract. Sometimes the timing of the assent will indicate that the party was induced by the threat to enter into the contract. So, for example, if the fact pattern says Bob refused Mary's demands, then Mary makes a threat, after which Bob assents to the contract, we can fairly assume that Mary's threat induced Bob to assent to the contract. There's one more issue we need to talk about in our discussion of duress, and that is the issue of affirmation. It's sometimes called ratification. Here's the issue. Once the risk of the threat is no longer present, the aggrieved party can affirm or ratify the contract. That affirmation can be express or it can be implicit. First, let's talk about an express ratification or an express affirmation of the contract. So imagine Bob enters into a contract with Mary after Mary made an improper threat. After the threat, whatever Mary threatened, there's no longer a risk of it. Bob might say, you know what, now that I think about it, even though I entered into this contract under duress, it's a good contract for me. Okay, I'm going to keep it, and I'm going to tell Mary that. Mary, even though I could void this contract, I am going to honor it. Now the aggrieved party has, Bob in this case, has affirmed the contract, and the party will lose its defense of duress. The affirmation or ratification by the aggrieved party could be implicit. Once again, after the risk of the threat is no longer present, if the other party keeps the benefit under the contract without expressly disaffirming the contract, then the aggrieved party has implicitly ratified or affirmed that contract. So look for this fact pattern. Look for a fact pattern where after there's no threat left, the risk of the threat is no longer present, but the aggrieved party keeps the benefit and doesn't disaffirm the contract within a reasonable time. You have to disaffirm it within a reasonable time. You have to say, I consider this contract void. If the aggrieved party doesn't do that, then the aggrieved party has affirmed the contract, implicitly affirmed the contract.